Alice here with part 162 of the My Docket series on child custody and visitation. As in my previous videos, we'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains a detailed disclaimer and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of this series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal in chronological order. This is a video that goes into my my attorney's response. We worked as a team, really. I mean, she was brand new in family law, so we very much worked closely together as a team on this case. Anyway, this is going to go into our response to my ex's attorney's nonsense, which is that there's nothing evil about what I'm doing. I'm owed a tremendous amount of money. I haven't received any money from over a year for her, and it's sad that her paying me $50 late should stop this entire process. It's not only sad, but it's inappropriate. Anyway, we can get into the specific laws that I cite when we actually get into the document. In fact, I guess the only thing I can say about my mindset at the time was that my attorney was anxious about it. She didn't know it was going to happen. She felt like it was going to be her fault if something came down on me. And I told her, you know what? If we get a bad order, I will appeal it. I will take care of it. I will get it fixed. And all of that happened. Something bad did happen. I did file an appeal, and I did get it fixed. But my attorney had a lot of anxiety over it. She just didn't want to feel like a bad attorney. She wanted to feel like she was helping. And when the judge came down with her imposition of sanctions, it made my attorney feel horrible. It made her feel like a horrible person. It's a lot easier for me to forgive what the judge did to me because I was able to get it corrected on appeal. But one of the things that I really find difficult to forgive about this judge is how much she tainted my attorney's perception of the legal industry. Because my attorney agreed with me that the law was on my side, that everything that I was doing was within the boundaries of the legislature's intent, and that it was there to help my son. And my attorney took away from this, you know what? The judges don't really care. They just do whatever they think is right, even if they're wrong. And so this is something that stuck with my attorney for years because, I mean, even to this day, I imagine she's never forgotten just how easily a judge can say, I don't care what the law says. You made me mad, therefore I will punish you. And it's completely wrong and it's unfair. And hopefully with our Nevada judges, this is something that we're able to change over time. But this is just something that I wanted to mention with regards to my mindset, because I haven't forgot about the impact that this particular series of motion practice had on my attorney. And it was there was a much more lasting effect on her than there was on me. I had already seen a lot of judicial incompetence all the way up to this point anyway, with my judge ordering midnight exchanges and all that stuff. So this wasn't new to me. This wasn't as much of a shock to me. I was just kind of shaking my head like, I can't believe it. I'm going to have to fix this too. And I did fix it. But for her, it very much formed her opinion as an attorney entering into the family law community, just what kind of judges she was going to have to deal with on the bench. In any event, I think at this point in time, we should just go ahead and get into what my attorney has filed. Here we have the opposition to motion to strike and render writ of execution void. Standard introductory paragraph indicating that I am represented by my attorney and that I am filing an opposition to my ex's motion to have that writ of execution quashed. We go into the points and authorities here. The Nevada Rules of Civil Procedure clearly outline service requirements. Rule 5 states in pertinent part. Let's see. Oh, wait. So I'm attacking the fact that they failed to serve me. They didn't even serve me with that motion? That's lovely. Well, I'm not going to spend a lot of time on this, guys. You all know how this works. The rules require that you serve somebody. They didn't serve me. So that's just one basis right there to object to this whole thing. It doesn't matter. I mean, on appeal, they destroy them using the law. But it's just interesting to me that they didn't even comply with Rule 5. My exes failed to serve the motion to strike on me. She filed a motion to strike December 31st. On or about January 2nd, my attorney searched the docket and found it. She found that this motion was filed and didn't get any, kind of notification at all. I'm going to go ahead and move through all of this because, I mean, it's a simple argument, guys. You have to fight. You have to serve somebody. Everybody knows about that. Everybody's seen Pineapple Express too. I think probably 95% of society has seen it. It's a funny movie. In any event, let's go ahead and go into the next section. Reliance on NRCP 11 and WDCR 23 is misplaced and taken out of context in this particular situation. Rule 11, which describes the process for sanctions, is taken out of context, and my ex's reliance on the same is misplaced. Likewise, Rule 23 bars a represented party from appearing in a case without consent of the court, and again, my ex's reliance thereupon is misplaced. The writ of execution, which is the subject of the present motion, is made in accordance with the Nevada Revised Statute 21 and was issued by the clerk. I knew it! That was my immediate instinct. Rule 77 states in pertinent part the clerk's office and orders by the clerk. The clerk's office with the clerk or a deputy in attendance is open during business hours, etc., etc. They execute judgments. They enforce judgments. That's their job. They enter defaults. The rules clearly state that attorneys and parties do not issue writs of execution. That's a completely ridiculous idea. And the fact that that attorney tried to say that leans me out of the category of he just didn't know what he was doing and he made a genuine mistake, and into the category of he was trying to induce this judge into committing reversible error, which he successfully did. Any attorney can win when the law's on the side. A really good attorney is good at deceiving the court into ruling in their favor when the law is not. Next section here. Writs of execution are issued by the clerk of the court. It is not affixed with the signature of an attorney or that of a pro se litigant, but rather with the signature of the clerk of the court. In this case, the deputy. So all of this guys already talked about earlier in this video. None of this makes any sense. It's a whole nonsensical notion that he has that my attorney has to sign the writ of execution because attorneys don't even sign it, period. And this guy had to have known this. I'm sure that he has issued writs of execution in the past, and I'm sure that he has noticed that he doesn't sign them. It's like, duh. Next section here. Writ of execution is not contrary to the court's order. So this is going to be probably more substantive. So my ex's argument that the court specifically stated how the judgment in this matter was to be satisfied, specifically that she had to pay $50 per month, simply because the court ordered my ex to satisfy her judgment by making $50 payments does not guarantee that the payments will be made, as we see in this case. If it was, then surely the legislature would have found no need to enact a statute allowing for a writ of execution on a judgment. Another duh moment. Just because somebody is ordered to pay doesn't mean that they will pay. Doesn't mean that I have to sit around and wait to be paid. They have enacted laws that allow you to seize money for a reason, because they want you to use them, because everyone uses them. They're used all the time. So this guy has invented this rule out of thin air that just because my ex is ordered to pay $50 per month, now I can't do anything else and I have to comply with that rule. That's not how it works, and the Court of Appeals is going to explain that to him. Additionally, the court did not order Respondent to pay $50 at her leisure. She is to pay the amount monthly every month until the judgment is satisfied. 30 days have lapsed since the November 4th, 2014 hearing, and my ex has made no effort to pay her $50 monthly obligation until after I filed my writ of execution December 12th, 2014. Even then, my ex's only effort to begin payment on the judgment was made on December 23rd when my ex's attorney issued a check for $50 to my counsel. Further, the December 8, 2014 court order specified that my ex's first child support payment to be made by December 1st, 2014. It is not unreasonable for me to infer that her first $50 payment to satisfy this judgment was also to be made on or before December 1st, 2014. Unfortunately, she didn't make either of the payments by December 1st, 2014. She didn't pay $50. She didn't pay child support. She hasn't paid that for over a year. And I am supposed to be nice to her now and assume that she's going to get back on track because she sent me just $50. The only hope that he had of me backing off was for her to send me both the $580 and the $50. It is beyond cruel to have forced me to take out all that student debt and all those credit cards to pay those thousands of dollars in surgery and then expect me to just back off because you sent me $50. This is just the most disgusting stuff that I just can't even... I don't know how these attorneys sign their name to these documents and not feel ashamed of themselves. And then again, I think about the video, win at all costs. And that's... I mean, guys, if you haven't seen the video, Win at All Costs, please watch it because that explains why they do what they do. Next section here. Respondent is not entitled to attorney fees. My ex alleges that she is entitled to attorney fees pursuant to Nevada Revised Statute 126.171 and based on me allegedly filing a fugitive document in contradiction with Rule 11 and Local Rule 23, and that the writ of execution is in direct contradiction to the court's order. Blah, blah, blah. Through the present opposition, I have made a sufficient showing that the writ of execution is not a fugitive document and that its issuance by the clerk is not in direct contradiction with this court's order. The fact that my ex chose to hire an attorney rather than pay $50 and her child support is going to underline that I have utilized all legal avenues available to me to collect the money. I am making a sufficient showing that the writ of execution was not issued in haste, but was only issued after 30 days had passed and I had not received payment by my ex. Further, let's see, it would be fundamentally unfair to allow me to be at the mercy of my ex and only receive payment when it fancied her, if ever. And guys, I just want to let you know, this $50, it's still a distraction. It is still a distraction because this $50, she stops paying anyway. She doesn't even pay this. She just goes right back into doing the same old thing. And it's like another year before I get money. I think there may be a point in 2016 when I start getting some payments, and that is about a year. So that's consistent with what I just said. So actually, I don't have to explain that. It's about a year in 2016 when I start getting money seized from her. Anyway, let's talk about that when we actually get to that point. Next section here. It has been well established that, quote, although a district court has discretion to award attorney fees as a sanction, there must be evidence supporting the district court's finding that the claim or defense was unreasonable or brought to harass, unquote. And that although a party, quote, did not prevail on the motion, and it may have been without merit, that alone is insufficient for a determination that the motion was frivolous, warranting sanctions, unquote. Rivero v. Rivero. I talk about this in the video, defend against attorney fees. It's not enough to lose on the motion. They have to win, and they have to show that I did so with the intent to harass. If they don't do both things, it will be overturned. I have to give you guys kind of a disclaimer here because a new law was passed in Nevada that I do believe is being abused. I talk about that law in the video, attorney fee equalizers. Please watch that video before you get excited, because that law has completely changed the game, and it makes it a whole lot easier for attorneys like this to get sanctions against parents. I think it's cruel that the legislature enacted that statute, but I want to let you guys know that there's a disclaimer. A new law was passed after this case, and definitely take a look at it because it could control your case in a different way. If a respondent was to prevail on motion to strike, she would not be entitled to fees because she failed to establish that the writ of execution was frivolously filed with the intent to harass. She was ordered to pay $50 per month in satisfaction of her judgment. She has failed to do so in a timely manner. She has made little effort to comply with the court's order. I move forward with my intentions to execute on the judgment. So even if I lose and that motion is granted, I am not harassing my ex. I have done all of this with a reasonable basis. Next section is the conclusion, the affirmation pursuant to the law. We got the Rule 5 certificate of service here. And we got the motion opposition notice here indicating that I did not have to pay a filing fee. We have two lists of two documents here. We have two emails. Let's take a look at these. Exhibit 1. So here is here's my attorney communicating with my ex's attorney. Actually, is there a bottom? No, there's not. Okay. Dear Mr. Oster, upon review of the above captioned case, I found that your office filed an opposition to motion for supplementary proceeding in the aid of execution and a motion to strike and render writ of execution void. At this time, I do not have a Washoe County eFlex account, and I have not yet received the documents in the mail. Therefore, I am requesting that you please email me a courtesy copy of the aforementioned documents, etc., etc. Next document. Dear Mr. Oster, please be... Wait. Yeah, okay. Please be advised that our son's inpatient dental procedure has been moved from January 7th, 2015 at 3 p.m. The procedure will take place at Dentistry for Kids. Additionally, at your earliest convenience, please send me the motions that your office filed with the court. Okay, so she's still not getting the documents, and he's just ignoring her. He's being a jerk even to my attorney. That's lovely. In any event, I'm going to go ahead and wrap this up. Going into the aftermath, I filed one document, but it was a free filing, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I had an attorney, but she is representing me for free, so I incurred $0 in attorney fees. My ex's attorney would have reviewed this opposition. There are some relevant statutes in it, but review of an opposition is not as big of a deal as filing of a reply. So I think most of his time is going to go into the filing of the reply to opposition. So I think it's pretty reasonable to say that 30 minutes for review of those statutes that we cited and communicating maybe with my ex on the issue. At the rate of $250 an hour, that will come to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.